victim advocate to ensure that he's one of the people that was let in. Your Honor, I believe he's now let in. Everyone in the waiting room's been let in.
All right, first of all, we're here this afternoon, correct that, it's still morning. We're here this morning in the matter of State versus Williams. Ms. Williams is standing before the court at this time. Good morning, ma'am. This is case number 65 on the calendar, case number 19 CF 11711. We're set for pretrial this morning. Counsel for the State and Defendant are present. Ms. Anderson, how are you proceeding today?
Your Honor, the State has tendered to Madam Clerk an amended information. I believe it's the second amended information in this case, charging a single count of second-degree murder.
In light of that, we need to move forward with an arraignment. I'll look to you, Mr. Beard. How are you proceeding today?
Yes, Your Honor. The defense is in receipt of the one count second amended information. At this point in time, my client would have authorized me to enter a plea guilty to that charge. We have gone over the pleading in its entirety. It's titled pleaded guilty. That would be a sentence between the range of 20 to 25 years of guidelines, which would have to do with my client on his life. That form has been completed, executed, and signed by my client, myself, and the State, and presented to your lawyer to proceed with the call.
All right. Go ahead and adjust the microphone for the benefit of your client. Ms. Williams, if you raise your right hand and be sworn, please. Excuse me. You solemnly swear the evidence you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Go ahead and put your hand down. Make yourself as comfortable as you can. Ms. Williams, the State has filed an amended information this morning. This is arraignment. Your lawyer has indicated that you want to enter a plea of guilty to the pending charge. You're charged with second-degree murder in the second amended information. That carries a range, a minimum range under the guidelines of 20.5 years all the way to life. As I understand it, given the nature of the form I've been given, this is an open plea to the court. What that means as a practical matter is that if you go forward with your plea today, I'll set a hearing. You'll be able to call witnesses on your behalf if you choose to. I'm glad to hear from you if you want to testify or give a statement yourself. The State also has a right to be heard. They can call witnesses, including any that they think appropriate. I'll consider any documentary evidence that's consistent with the evidence code. And then I'm going to hear arguments from the lawyers. And based on everything I hear, I'm going to fashion a sentence that I think is appropriate. You're entitled to a pre-sentence investigation report. What would happen is that the Department of Corrections would conduct an investigation and complete a document for me that would provide me with a whole host of information that I don't otherwise get. Mr. Beard, I assume your client is requesting a PSI?
Yes, Your Honor, we've discussed that, and we'll be asking for a PSI.
I'll go ahead and look to the Department of Corrections at this time and ask that it be prepared. That'll be an additional source of information. I'm going to take all of that information, and then after I hear arguments from the attorneys and consider the evidence that's been presented before me, I'll fashion a sentence that I think is appropriate. Unless there is a basis to deviate below the guidelines, which is 20.5 years, that's the minimum sentence that I can impose under the law, and the maximum sentence I can impose under the law is life. 20.5 years for the maximum sentence. With your plea today.
Yes, sir.
Right, so you give up your right to trial by jury, the right to compel the attendance of witnesses and witnesses against you, the right not to require the State to prove you guilty on a reasonable related to any judgment in your case, and if you're not in a deportation proceeding, Ms. Williams pleaded guilty.
Yes, sir.
Promised you anything to get you to plead guilty.
No.
All our medication today.
No, sir.
How far? Can are you a graduate?
Yes, sir.
I ask you that because I have in my hand this with your lawyer.
Yes, sir.
Do you understand? Signing the document, you give up the rights described in it. It appears on the back page.
Yes, sir.
The only count of the amended charge guilty.
Yes, sir.
Has your lawyer answered all? With his representation as your attorney? Status of your case or its disposition? Anything you wanted your lawyer to do that has he done something that you didn't want him to do? Is the state or defense aware of any DNA?
None to the state at this time.
Defense? Of the record, what discovery has out on the previous charges?
I don't have the figure exact, but I would say things have been conducted for review. 20, the provided by the state to go through every individual record. And I've gone through it, I prepared that, and more specifics I can provide that, however, at this time, that is, I sufficiently reviewed and explained it to my client.
Have you reviewed the content of each of the depositions you've taken with your client?
Yes.
Have you reviewed the substance of each item of discovery that the state has produced consistent with the rules?
Yes.
Have you also discussed with your client potential defenses and options?
Yes, Judge.
Ms. Williams, has your lawyer done all of that?
Yes, sir.
And so you have considered the evidence that the state has to present through the depositions that your lawyer has taken, as well as the other discovery items that have been presented for your consideration? Have you reviewed all of that?
Yes, sir.
Have you talked to your lawyer about the options that you have? You have an absolute right to trial by jury, and I'm happy to move the case on toward a jury verdict if that's what you choose to do. Have you talked with your lawyer about all the options you have?
Yes, sir.
Have you discussed potential defenses that you may have with your lawyer?
Yes, sir.
And out of all of those conversations, do you believe that this is in your best interest?
Yes, sir.
I should say, in light of all of those conversations, do you believe this to be in your best interest?
Yes, sir.
State factual basis for purposes of the plea.
Yes, Your Honor. In this case, we're to proceed to trial. The state would prove beyond a reasonable doubt that Brianna Williams on or between April 17th of 2019 and November 6th of 2019 in the County of Duval, state of Florida, did unlawfully and by an act eminently dangerous to another and evidencing a depraved mind, regardless of human life, kill Taylor Rose Williams, a human being, contrary to provisions of Section 782.04, paren 2 Florida statute. Specifically, between those dates, she pulled her 5-year-old daughter from all child care facilities. She failed to find adequate child care for her daughter and left her daughter home alone at her apartment located on the south side of Jacksonville, while she, Brianna Williams, went about her daily affairs, including going to work for sometimes as long as 12-hour shifts. Taylor Rose Williams was observed by neighbors in the complex wandering outside alone. She told the neighbors that she was looking for her mom. They ushered her back into an empty apartment and told her to lock the door. On November 6th of 2019, Brianna Williams called 911 and reported that Taylor Rose Williams had gone missing and was potentially kidnapped from a second residence on Ivy Street. The odor of decomposition was observed by officers as well as a trained canine coming from the trunk and backseat of Brianna Williams' car parked at the residence. Police quickly determined that the defendant's kidnapping to be suspect and began a search spanning multiple states for the 5-year-old. Ultimately, Taylor Rose Williams' remains were found in Alabama, close in proximity to Brianna Williams' hometown. Detectives were led to the exact location through a download of the infotainment center in Brianna Williams' car. Those remains were confirmed through forensic testing to be that of 5-year-old Taylor Williams. The apartment of Brianna Williams was thoroughly searched, photographed, and evidence was collected. Obvious signs of neglect and abuse were observed, including soiled children's clothing, soiled carpeting, blood, and along with hands that had a tiny hole cut in them. Taylor Rose Williams' remains consisted of approximately 10% of her bones. The bones were scattered around the recovery area, and those remains were sent to be examined by the medical examiner's office as well as a forensic anthropologist. A determination was made that some of the recovered remains showed evidence of potential malnourishment, trauma, or disease. Finally, a download of Brianna Williams' computer was conducted where searches were discovered for malnutrition and refeeding syndrome. The state will be presenting an extensive amount of witnesses as well as other evidence during the course of the sentencing hearing, but that is the factual basis for today.
So that would happen for purposes of the plea.
Yes, Your Honor, we stipulate.
Ms. Williams, your lawyer has stipulated to the accuracy of that rendition. Do you dispute that?
No.
I find a factual basis for purposes of the plea. Just so that you're aware, although you've got no criminal history, one of the obligations I have is to advise you that if you have a sex-related crime as part of your criminal history, it may qualify for involuntary civil commitment pursuant to Jimmy Rice. I don't expect that to apply in your case since you have no criminal history, but it needs to be part of the plea colloquy. With all of that said, are you entering a plea of guilty at this time to the only count of the second amended information charging murder in the first degree?
Yes, sir.
I accept your plea of guilty, finding it to be freely and voluntarily entered with full understanding of its nature and consequence. What I intend to do next is set a hearing date. My intent is to pass the matter for at least a month. I'll look to the parties to give me guidance as to what they want in order to make sure they're fully prepared. I'll look to the state first. How much time do you need, Ms. Anderson?
Your Honor, just one correction. I believe you just said murder in the first degree.
I beg your pardon?
Murder in the second degree.
I accept your plea of guilty with respect to murder in the second degree, and I apologize for that. I have misspoken.